ladies and gentlemen, students, scholars, teachers, trainers, professors, professionals, officers, official business learners. I welcome all respected officers and directors. I welcome honorable ministers, managers. I welcome honorable advocates, advertiser administrators, advisors. Welcome the most eligible present permission. Really nice time, nice place, nice section that we are defining, explaining, expressing our truly Indian spiritual, educational, constitutional identities in the form of unity and diversity. Advisory, advisory jurisdiction, advisory jurisdiction. Besides contentions jurisdiction, besides contentions jurisdiction, the court also possesses advisory jurisdiction. The General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on legal question. Other organs of the UN and specialized agencies, which may at any time be so authorized by the General Assembly, may also request advisory opinions of the court on legal questions arising within the scope of their activities. It may be noted here that pursuant to the above provision, the General Assembly has authorized the Economic and Social Council, the Trusteeship Council, 14 specialized agencies of the UN, the International Atomic Energy Agency, Interim Committee of the General Assembly, and Committee on Application for Review of Administrative Tribunal judgments to request advisory opinions of the court. Thus, among the principal organs, only Secretariat has not been authorized to request advisory opinions of the court. It has therefore been rightly suggested that the Secretary General should also be authorized to request advisory opinions on legal questions within the scope of his activities. Several other suggestions have been made to widen the scope of advisory jurisdiction of the court. Among such suggestions, the suggestion to develop a procedure to allow national tribunals to refer complex issues of international law for advisory opinion of the court merits serious consideration, building on the precedent of the establishment of a committee on applications for review of administrative tribunals judgments in 1955. It has been suggested that the General Assembly should create an organ of the UN, especially for the purpose of requesting advisory opinions in defined circumstances. It has been pointed out that while the International Court of Justice would provide a uniform interpretation of rules of international law, it would be for the national tribunals to decide how to apply that rule, if at all in a particular case before it. This suggestion has been recently sought by American Bar Association, as pointed out by Louis B. Sohan. The novel feature of the procedure proposed by the American Bar Association is that requests from national courts would not go directly to the International Court of Justice but would be filtered through the Special Committee of the General Assembly. While entitled to submit the question to the Special Committee of the General Assembly, while entitled to submit the question to the court, the Special Committee would not be obliged to do in every case. It does not seem it does not seem desirable to give restricted access to the court to possibly hundreds or even thousands of national courts, as such access might overwhelm the court with trivial, inappropriate, needlessly involved, unripe, and politically sensitive cases. The various issues raised by the ABA proposal are being explored now in Congress and at the UN, although there are obstacles to be overcome before this proposal is realized. The task is not impossible. It may, however, take a while. It may be noted that while in case of committee on application for review of administrative tribunals judgments, it has been agreed in advance that the UN Administrative Tribunal would be obliged to advise its judgments in conformity with the opinion of the court. The same might not be possible in case of national tribunal advice, obviously, on account of the concept of national sovereignty, which the states continue to be jealously guarding, according to Article 65 of the State of the International Court of Justice. One is the court may give an advisory opinion on any legal questions at the request of whatever body may be authorized by or in accordance with the Charter of the UN to make such a request. To each question upon which the court is asked shall be led before the court by means of a written request containing an exact statement of the question upon which an opinion is required and accompanied by all documents likely to throw light upon the question. The statute of the court further provides that the court shall deliver its advisory opinions in open court, notice having been given to the Secretary General and to the representatives of members of the UN, of the other states, and of international organizations immediately concerned. Besides this, in the exercise of its advisory functions, the court shall further be guided by the provisions of the present statute, which apply in contentious cases to the extent to which it recognizes them to be applicable. In the interpretation of peace treaties case, first phase, the International Court of Justice observed in its advisory opinion the consent of states to a dispute is the basis of the court's jurisdiction. In the contentious cases, the situation is different in regard to an advisory proceedings, even where the request for an opinion relates to a legal question actually pending between states. The court's reply is only of an advisory character. As such, it has no binding force. It follows that no state, whether a member of the UN or not, can prevent the giving of an advisory opinion which the United Nations consider to be desirable in order to obtain enlightenment as to the course of action it should take. The court's opinion is given not to the states but to the organ of the United Nations. Represents the participation in the activities of the organization and in principle should not be refused. Thus, the advisory opinion itself does not constitute per se decision with which anyone is legally bound to comply. According to Corbett, advisory opinions are of course not binding of, but they do embody the most authoritative possible statements of existing norms. To disregard them is not outright defiance of the principal judicial organ of the UN. It does, however, diminish the prestige of tribunal and that it is a disservice to the cause of world law. According to Judge Nagendra Singh of the ICJ, advisory opinions are authoritative statements of the existing law, and their disregard will lower the prestige of the court. They are of great value in building public opinion. In his view, the statute of the court should be amended to broaden the advisory jurisdiction for it will contribute immensely to the development of international law. If the provisions of Article 96 of the UN Charter are strictly interpreted, the ICJ is not bound to give an advisory opinion. But as noted, since the court itself is an organ of the UN, the reply of the court, that is advisory opinion, represents its participation in the activities of the organization and in principle should not be refused. But the court can be requested to give advisory opinion on any legal question only, and hence if the question referred to it is not legal, the court may refuse to give its opinion. The court may also refuse to give advisory opinion if the provisions of the UN Charter and the statute of the court referred are not complied with. In its advisory opinion concerning the interpretation of the agreement of 25th March 1951 between the WHO and Egypt, the International Court of Justice observed, if it is to remain faithful to the requirements of its judicial character in the exercise of its advisory jurisdiction, must ascertain what are the legal questions really in issue in questions formulated in request. Furthermore, a reply to question of this kind posed in the present request may, if incomplete, be not only ineffectual but actually misleading as to the legal rules applicable to the matter under consideration by the requesting organization. For this reason, the court could not adequately discharge the obligation incumbent upon it in the present case if in replying to the request it did not take into consideration all the pertinent legal issues involved in the matter in which the questions are addressed. Court's competence in respect of determination of its own jurisdiction. In the event of a dispute as to whether the court has jurisdiction, matter shall be settled by the decision of the court. For example, in case concerning the aerial incident of 4th September 1954, US versus USSR, the court held it has not before it any acceptance by the government of Union of Soviet Socialist Republic of the jurisdiction of the court to deal with the dispute which is subject of the application submitted to it by the government of the United States of America, and that therefore it can take no further steps upon the application. Similarly, in Anglo-Iranian Oil Company case, the court held that it had no jurisdiction to decide the case as it was related to territorial sovereignty of Iran. In a more recent case, fisheries jurisdiction UK versus Iceland case, the court by majority of 14 held that it had jurisdiction to decide the case. This case concerns the declaration of fisheries jurisdiction by Iceland. Britain filed the case against Iceland, but the latter had contended that the court had no jurisdiction to decide the case. In a recent case, namely Fisheries jurisdiction case, Spain versus Canada, the International Court of Justice pointed out that the establishment or otherwise of jurisdiction is not a matter for the parties but for the court itself. Although a party seeking to assert effect must bear the burden of proving it, and this has no relevance for the establishment of the court's jurisdiction, which is a question of law to be resolved in the light of the relevant acts. That being so, there is no burden of proof to be discharged in the matter of jurisdiction. Rather, it is for the court to determine from all the facts and taking into account all the arguments advanced by the parties, whether the force of argument militating in favor of jurisdiction is preponderant, and to ascertain whether an international intention on the part of parties exists to confer jurisdiction upon it. In the instant case, that is a fisheries jurisdiction case, Spain versus Canada, decided by the World Court on December 4th, 1998, Spain had filed the case on 28 March 1995, instituting proceedings against Canada in respect of a dispute relating to the amendment on 12th May 1994 of the Canadian Coastal Fisheries Protection Act, as well as to specific action taken on the basis of the amended Act and its regulations, including the pursuit, boarding, and seizure on the high seas on 9th March 1995 of a fishing vessel. The Este flying the Spanish flag, Spain invoked as the basis of the jurisdiction of the court the declarations whereby both states have accepted its compulsory jurisdiction in accordance with Article 36, paragraph 2 of the statute. Canada, on the other hand, took the stand that the court lacked jurisdiction to entertain the application because the dispute was within the plain terms of the reservation in paragraph 2D of the Canadian Declaration of 10th May 1994. The International Court of Justice accepted the stand of Canada and held that it had not jurisdiction to adjudicate upon the dispute brought before it by application filed by the Kingdom of Spain on the 28th March 1995. Reference may be made here to the case of armed activities on the territory of Congo. New application 2002 Islamic Republic of Congo versus Rwanda 2002 to 2006, decided by the International Court of Justice on 3rd February 2006. In this case, the court found that it had no jurisdiction to entertain the application filed by the Democratic Republic of Congo. The court also pointed out the fundamental distinction between the acceptance by states of the court's jurisdiction and the conformity of their acts under international law. The court observed that it has stated in numerous previous occasions that there is a final distinction between the question of acceptance of the court's jurisdiction and the conformity of their acts with international law. Whether or not states have accepted the jurisdiction of the court, they are required to fulfill their obligations under the UN Charter and the other rules of international law, including international humanitarian and human rights law, and they remain responsible for acts attributable to them which are contrary to international law. Problem of the enforcement of the judgments of the International Court of Justice. As noted earlier under Article 19.4 of the United Nations Charter, the Security Council is empowered to implement the judgments of the World Court in case one of the parties fails to implement it and other party to the dispute brings the matter to the Security Council. The problem of enforcement of judgment of the International Court which came before the United Nations was not experienced by the League of Nations. That is to say, states refuse to accept obligations arising out of the judgments of the court. This happened particularly in the Corfu Channel case. A recent case in which also this problem arose was the nuclear test case. The framers of the charter were of the view that this was not the function of the court and hence they entrusted this work to the Security Council. According to Fawcett, except in the Corfu Channel case, the problem of the enforcement never seriously arose, and even in that case, on the refusal of Albania to pay compensation, England had confiscated Albanian money in England. A brief reference may be made here to the case of monetary gold removed from the Rome in 1943. Italy versus France, UK, and US in 1943, a certain quantity of monetary gold was removed by the Germans from Rome. Later on, it was recovered in Germany and found to belong to Albania. The 1946 Agreement on Agreement on Reparation from Germany provided that monetary gold found in Germany should be pooled for distribution among the countries entitled to receive a share of it. The UK claimed that the gold should be delivered to it in a partial satisfaction of the court's judgment in 1949 in the Cortu Channel case, but Italy claimed that the gold should be delivered to it in a partial satisfaction for the damage which it alleged it had suffered as a result of an Albanian law of 13 January 1945. In the Washington Statement of 25th April 1951, the government of France, the UK, and the US decide that the gold should be delivered to the UK unless within a certain time limit Italy or Albania applied to the court requesting it to adjudicate on their respective rights. No action was taken by Albania. Italy, however, made an application to the court, but later on, Italy raised the preliminary question as to whether the court had jurisdiction to adjudicate upon the validity of the Italian claim against Albania. In its judgment of 15 June 1955, the court held that without the consent of Albania, it could not deal with a dispute between that country and Italy, and that it was therefore unable to decide the question submitted. Thus, we see that there was partial enforcement of the judgment of Corfu Channel case against Albania. In the words of an author, there are not more than a few cases out of many hundreds which have involved the refusal by the losing party to give effect to an award rendered. According to Michael Akehurst, most judgments by international courts and arbitral tribunals have been obeyed by the states concerned. A few cases of disobedience have received a lot of publicity, but the cases in which judgments have been obeyed, although receiving less publicity, are far more numerous. Sometimes states reject a judgment at first, but obey it later. The basis of international adjudication is thus the consent of state parties to dispute. This consent gives rise to certain obligations of a legal character, which constitute the basis of the obligation to comply with the resultant judgments of international tribunal. Thus, refusal to comply with the judgments of an international tribunal is ipso facto a breach of an international legal obligation. It may also be noted that the problem of sovereignty of states does not come in the way of the enforcement of judgments of the court. Recently, the problem of the enforcement of judgment of the court has once again assumed serious magnitude in the case concerning military and paramilitary activities in and against Nicaragua. Nicaragua versus US. The US has refused to comply with the decision of the court. Contribution of International Court of Justice in the codification and progressive development of international law. It is one of the functions of the United Nations to make the progressive development of international law and its codification. The International Court of Justice as the principal judicial organ of the United Nations has done commendable work in this construction. The World Court has contributed much in the progressive development of international law. The International Court of Justice has been able the International Court of Justice has been able to make the progressive development of international law One is when there is no international treaty or convention on a particular point in dispute. The court has provided under Article 38 of the Statute of the International Court of Justice can apply the general principles of law recognized by the civilized states and therefore contribute to the progressive development of international law. It clarifies the vague rules of international law. The International Court of Justice has directly contributed towards ensuring respect for international law. It had gone a long way to remove lacuna and to clear up obscurities and fully emphasize the role of law in present day international relations. In the reparation for injuries case, the court said it is here posed with a new situation. The question which it gives rise to can only be solved by realizing that the situation is dominated by the provisions of the Charter considered in the right of the principles of international law. In another case, the court observed in seeking to determine the law applicable to this case, the court has to bear in mind the continuous evolution of international law. In fisheries jurisdiction case, it observed the possibility of the law changing is ever present. In Western Sahara case, the World Court observed more emphatically the reference in those questions to a historical period cannot be understood to fetter or hamper the court in the discharge of its judicial function. That would not be consistent with the court's judicial character. For in the exercise of its function, it is necessarily called upon to take into account existing rules of international law. Similarly, in its judgment of 3 June 1985, in case concerning the continental shelf, Libyan Arab Jumeirah or Malta, the court observed that convention, that is 1982 Convention on the Law of the Sea, had not yet come into force and therefore not operative as treaty law. Nevertheless, it cannot be denied that the 1982 Convention is of some major importance, having been adopted by an overwhelming majority of states. Hence, it is clearly the duty of the court, even independently of the references made to the convention by the parties, to consider what degree any of its relevant provisions are binding upon as a rule of customary international law. In an earlier case, the court held that the exclusive economic zone may be regarded as part of modern international law. This was quoted with approval in the Go case. Although Article 59 of the Statute of the International Court of Justice undermines or even prohibits doctrine of precedent by providing that the decisions of the court shall not be binding except upon the parties to a dispute, and only in that dispute, yet the court does not ordinarily deviate from its past decisions. In order to understand properly the progressive development of international law by International Court of Justice, it will be necessary to discuss briefly some of the cases decided by the court. A brief discussion of those cases is given. Cases decided under contentious jurisdiction. Cases decided under contentious contentious jurisdiction. The main cases decided by the court under its contentious contentious jurisdiction. One is Anglo Norwegian fisheries case. In this case, the court held a Norwegian decree of 1935 delimiting an exclusive Norwegian fishing zone by reference to a state-based line drawn through 48 selected points on the main line or island or rock at a considerable distance from the coast, from which baseline of the breadth of the territorial sea was to be measured was not contrary to international law. Thus, the court clarified the law relating to the determination of fisheries zone by the state. In this case, the court also made it clear that it is not bound by the past decisions and precedents and is free to make the progressive development of international law. The Corfu Channel case. In this case, the court clarified law relating to self-defense, intervention, and innocent passage. The Ashlam Colombia versus Peru case. In this case, the court clarified the law relating to Ashlam. Mancures and Acrihos, France versus UK. In this case, the court emphasized that for acquisition of territory through occupations that was of decisive importance was not indirect presumption based on matters in Middle Ages, but direct evidence of possession and the actual exercise of sovereignty. Note Boham. In this case, the court propounded the principle of effective nationality. North Sea continental shelf case. In this case, the court interpreted Article 6 of the Geneva Convention on continental shelf and held that the principle of equidistance was not obligatory in all cases of delimitation of continental shelf. The court also clarified the general concept of continental shelf, which made a great impact on state practice and development of international law in this respect. Nuclear test case, June 22, 1973. In this case, court clarified law relating to state responsibility in respect of conduct of nuclear test. For details of the case, see laws of aerial warfare. Next, number 8 is fisheries jurisdiction merit case, UK and Northern Ireland versus Iceland. In this case, the court clarified the law relating to validity of the establishment of the fisheries jurisdiction by Iceland and the concept of preferential rights. The court held the concept of preferential rights is not compatible with the exclusion of all fishing activities of other states. The coastal state entitled to preferential rights is not free unilaterally and according to its uncontrolled discretion to determine the extent of those rights. The characterization of coastal states' rights as preferential implies a certain priority, but a state which, like the applicant, has for many years been engaged in fishing in the waters in question, such fishing activity being important to the economy of the country concerned, the coastal state has to take into account and pay regard to the position of such other states, particularly when they have established an economic dependence on the same fishing grounds. Accordingly, the fact that Iceland is entitled to claim preferential rights does not suffice to justify its claim unilaterally to exclude the applicant's fishing vessels from all fishing activity in the waters beyond the limits agreed to in the 1961 Exchange of North. Aegean Sea Continental Shelf Case, Greece versus Turkey, decided on September 11, 1976. In this case, the court clarified law relating to grant of interim measures of protection. This has been referred earlier under the heading Interim Measures or Relief. Case concerning United States diplomatic and consular staff in Tehran. In this case, the court interpreted and applied Vienna Convention on Diplomatic Regulation 1951 and Vienna Convention on Consular Relations 1963. This case related to the taking of employees of American Embassy and Consular in Tehran by Iran. The court held Iran guilty of violation of the above-mentioned convention and directed Iran to pay compensation to America. The World Court reaffirmed the cardinal importance of international law relating to privileges and immunities of diplomatic envoy. Case concerning continental shelf. Tunisian Libyan Arab Jumeirah. Judgment dated 24th February 1982. This case dealt with the delimitation of continental shelf between adjacent states. The court clarified the law in this connection, principles to be applied, relevant circumstances to be taken into account, and the practical method for application of the principle. Case concerning military and paramilitary activities in and against Nicaragua. Nicaragua versus US. In this case, the court on 10th May 1984 indicated provisional measures asking the US to immediately seize and refrain from any action restricting, blocking, or endangering access to or from Nicaragua ports, and in particular, the laying of mines. The court also dwelt upon the principles of non use of force and non intervention. Case concerning the continental shelf. Libyan Arab, Jumeirah, Malta. Judgment dated 21st March 1984. In this case, the court clarified the law related to application to intervene under Article 62 of the Statute of Court. This case has been discussed in a little detail earlier in this chapter. Case concerning delimitation of the maritime boundary in the Gulf of Marine Area, Canada versus US. Judgment of 12th October 1984. In this case, the court clarified the law relating to delimitation of continental shelf between the two states. This case has also been discussed in detail in chapter on the law of the sea. Case concerning military and paramilitary activities in and against Nicaragua. Nicaragua versus United States of America. Judgment of 26 November 1984. In this case, the court interpreted Article 36, paragraph 2 and 5 and clarified law relating to admissibility of application. This case has been discussed earlier in this chapter under the heading Transferred Jurisdiction. Case concerning the continental shelf, Libya versus Malta, judgment of 5th June 1985. This case deals with the delimitation of the continental shelf between opposite coasts and has been discussed in a detailed detail in chapter 1, the law of the sea. Case concerning military and paramilitary activities in and against Nicaragua. Nicaragua versus United States of America, ICJ reports 1986, page 14. In this case, the court clarified rules relating to intervention and collective self-defense. This case has been discussed in intervention. A case concerning Electronica, Siculica SPA, United States of America versus Italy, judgment of 12th July 1989. In this case, the word court expounded the principle relating to the applicability of the rule of exhaustion of local remedy. This case has been discussed in detail in treatment of aliens. It may be noted that a case concerning military activities in and against Nicaragua is the 52nd contagious case brought before the court. Land Island and Maritime Disputes case, El Salvador versus Honduras. This case deals with the right of a third state which is not a party to the dispute to intervene in dispute in which its interest may be affected. This has been discussed earlier. Fisheries jurisdiction case, Spain versus Canada. This case deals with interim measures for interim relief and has been discussed. Case concerning the Vienna Convention on Consular Relations, Germany versus United States of America. This case deals with the competence of the court to determine whether it has jurisdiction in the case or not. Case concerning the legality of the use of force, Yugoslavia versus US. This case also deals with the competence of court to determine whether it has jurisdiction or not. Arrest warrant of 11th April 2000, Democratic Republic of Congo 2004. In this case, the word court clarified the law relating to immunity from criminal jurisdiction and the inviolability of Minister of Foreign Affairs. While visiting other countries, this case has been discussed in detail in diplomatic agents. Application for the revision of the judgment of 11 July 1996 in the case of concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia versus Herzegovina versus Yugoslavia 2003. In this case, the International Court of Justice clarified the legal position relating to preliminary objections in its judgment dated 3rd February 2003. The court ruled that once it is established that the request for revision fails to meet one of the conditions for admissibility, the court is not required to go further and investigate whether the other conditions are fulfilled. Avena and other Mexican nationals, Mexico versus United States of America in 2004. In this case, the court ruled that the United States of America had breached its obligations to Mr. Avena and 50 other Mexican nationals and to Mexico under Vienna Convention on Consular Relations, certain property 2005. The Victorian age and its works. A glance at even the titles which Browning gave to his best known volumes, Dramatic Lyrics 1842, Dramatic Romances and Lyrics 1845, Men and Women 1855, Dramatize, Dramatis Persona 1864, will suggest how strong the dramatic element is in all his work. Indeed, all his poems may be divided into three classes: pure dramas like Starford and A Blot in the Statuan, dramatic narratives like Pippa Passage, which are dramatic in form but were not meant to be acted, and dramatic lyrics like The Last Ride Together, which are short poems expressing some strong personal emotion or describing some dramatic episode in human life, and in which the hero himself generally tells the story. Though Browning is often compared with Shakespeare, the reader will understand that he had very little of Shakespeare's dramatic talent. He cannot bring a group of people together and let the actions and words of his characters show us the comedian tragedy of human life. Neither can the author be disinterested satisfied as Shakespeare was with life itself without drawing any moral conclusions. Browning has always a moral ready and insists upon giving us his own views of life. Which Shakespeare never does. His dramatic power lies in depicting what he himself calls the history of Saul, sometimes as in Paracelsus. He endeavors to trace the progress of the human spirit. More often, he takes some dramatic moment in life, some crisis in the ceaseless struggle between good and evil, and describes with wonderful insight the hero's own thoughts and feelings. But he almost invariably tells us how, at such and such a point, the good or the evil in his hero must inevitably have triumphed, and generally, as in my last Duchess, the speaker adds a word here and there. Aside from the story, which unconsciously shows the kind of man he is, it is this power of revealing the soul from within that causes Browning to fascinate those who study him long enough. His range is enormous and brings all sorts and conditions of men under analysis. The musician in Abt Vogler, the artist in Andrea del Sarto, the early Christian in A Death in the Desert, the Arab horseman in Mulike, the sailor in Harverial, the medieval knight in Child Roland, the Hebrew in Saul, the Greek in Beloson's Adventure, the monster in Caliban, the immortal dead in Tarshish, all these, and 100 more histories of the soul show Browning's marvelous versatility. It is this great range of sympathy with many different types of life that constitutes Browning's chief likeness to Shakespeare, though otherwise there is no comparison between the two men. If we separate all these dramatic poems into three main periods, the early from 1833 to 1841, the middle from 1841 to 1868, and the late from 1868 to 1889, the work of the beginner will be much more easily designated of his early soul studies. Pauline, 1833, Paracelsus, 1835, and Sordilla, 1840. Little need be said here, except perhaps this, that if we begin with these works, we shall probably never read anything else by Browning, and that were a pity. It is better to leave these obscure works until his better poems have so attracted us to Browning that we will cheerfully endure his worst faults for the sake of his undoubted virtues. The same criticism applies, though in less degree, to his first drama, Strafford 1837, which belongs to the early period of his work. The merciless criticism which greeted Sordello and had a wholesome effect on Browning, as is shown in the better work of his second period. Moreover, his new power was developing rapidly, as may be seen by comparing the eight numbers of his famous bells and Pomegranates series 1841 to 1846 with his earlier work. Thus, the first number of this wonderful series, published in 1841, contains Pipa Passe, which is, on the whole, the most perfect of his longer poems, and another number contains a blot in the Scutcheon, which is the most readable of his dramas. Even a beginner must be thrilled by the beauty and the power of these two works. Two other noteworthy dramas of the period are Columb's Birthday 1844 and in a Balcony 1855, which however met with scant appreciation on the stage, having too much subtle analysis and too little action to satisfy the public. Nearly all his best lyrics, dramas, and dramatic poems belong to this middle period of labor, and when The Ring and the Book appeared in 1868, he had given to the world the noblest expression of his poetic genius. In the third period, beginning when Browning was nearly 60 years old, he wrote even more industriously than before and published on an average nearly a volume of poetry a year. Such volumes as We Find at the Fair, Red Cotton Nightcap Country, The Eind Albumen, Jacosia, and many others show how Browning gains steadily in the power of revealing the hidden springs of human action, but he often rambles most tiresomely, and in general his work loses its sustained interest. It is perhaps significant that most of his best work was done under Mrs. Browning's influence. Paramatmane Namaha. Oh dear Lord, you are mine. Oh dear Lord, you are mine. Only you are my mother and father. Only you are my kin and companion. Only you are my knowledge and riches. Oh dear Lord, it is you all in all. There are innumerable ways to attain God realization. Although all those paths, I have found a unique path which is uncommon. It's I belong to God. You may perceive this as ordinary, but in my opinion, it is extremely unique. Each one of us is God's child. It is not a usual fact. This renders God realization exceedingly easy. The disciple put a question in front of Swamiji. Swamiji, earlier you instructed us regarding seeking refuge in God and chanting His name. Then you asked us to regularly repeat, "Oh, my dear Lord, I must never forget you," and now you are telling us to accept our belongingness to God. Which of these sadhanas should we follow? Swamiji says, all of which I am instructing you now. All sadhanas are excellent, but accepting that God is mine, this makes us close to God. The closer we are to God, the better the worship becomes. One more question was whether put by the disciple carrying out all deeds of diligently or disregarding our belongingness with the material world or accepting our belongingness to God, we should must the three sadhanas as the most appropriate to break away from our attachment and aversion and attain liberation. Swamiji says accepting our belongingness to God is the foremost sadhana because of our acceptance of the belongingness to God. By the virtue of God's grace, attachment and aversion are also resolved. Equivalency also comes, serenity is also attained, and liberation is also fulfilled because in our essence we are fragments of God. Mame Vansho Jeev Loke. By correcting this essence, everything else gets corrected. If we wish to effortlessly experience God, it is my request that you must accept I belong to God. This practice is much more powerful than Jog Sadhana. For instance, a daughter in your family once married accepts that I belong to my husband's space. Similarly, you must accept that I belong to God. This is an extremely effortless and preeminent sadhana. God had Himself specified this as the ultimate untold secret, Sarvguhatma. In the entire instruction of the Gita, the term Sarvguhatma has been used only once. I am daily stating this with folded hands that, in my opinion, this is the foremost sadhana. I feel so in my heart that if we accept that God belongs to us, then our task will be quickly done. God is mine. If this is accepted, then a whole lot of our work is done. We have already come quite close to God. All that you wish to depart from would be achieved by God's grace, God's strength only. In Jnana Yoga and Karma Yoga, both sadhana, path, and sadhya destination are distinguishable, whereas in Bhakti Yoga, God Himself is the sadhana as well as the sadhya. That's why the path of Bhakti Yoga is comparatively brisker to treat. Everybody is not aware of this fact. That's why I keep on emphasizing that you must accept your belongingness to God. God is our Father. Each one of us is beloved son and daughter. Accept this and consider most of your work completed. It It is better than God's continual remembrance to accept our relationship with God, that I belong to God relationship is ever existing. Once the relation is embraced, then God's remembrance occurs inherently and doesn't have to be practiced. It happens without any effort. I have a mother in this manner. We have accepted our mother. Now, now we are not required to remember this. Like a rich man is always proud from within that I have so much money. Similarly, you should also at all times feel proud from within that I belong to God. As abhiman जय जन भोरे मैं सेवक रघुपति पति मोरे. However you are, you must never disregard the fact that I belong to my Lord. Be it happiness or sorrow, health or sickness, profit or loss, but I belong to God, God belongs to me. Your mind must never dwindle from this principle. There is no equivalent path, no ability, no strength nor privilege than acceptance of our belongingness to God. In the acceptance of God's belongingness, the mind, the intellect, etc. are not required, whereas in other sadhanas, the assistance of the mind, the intellect, etc. are required. Even with the persisting absence of certain traits in a seeker, God chooses to concentrate only on the belongingness and not the absent traits because our belongingness to God is absolute. He who accepts his relation with God rises above the ordinary. He becomes a Sant Mahatma, he attains serenity and eternal joy. He becomes carefree of everything else. So accept that God belongs to you and relax. I belong to God, never forget this. And you will certainly experience God. You will be naturally introduced to Satsang and Sant Mahatma. The most exceptional thing is an eternal relationship with God. By the virtue of the acceptance of the relationship, there is rapid augmentation. Chanting of God's name, meditation, kirtan, etc. are not perpetual, and there is always some interference, whereas there is no interference in the relationship with God. For example, by sleeping, the marital relationship doesn't vanish. Similarly, in forgetfulness or sleep, our relationship with God doesn't vanish. It is perpetual and ever existing. There is exhaustion in performing chanting, etc. But a relationship is never tiring. This relationship is immediate and eternal. Like marriage breaks only if you break it. If you accept that God belongs to me, then not even God can break this. The jiva or the embodied soul is a fragment of God. Therefore, if he connects with God by any means, he is certainly liberated. A relationship with God invariably leads to supreme welfare. Those who took God by enmity, like Kansha and Shishupala, etc., were liberated, and those who loved God utterly were also liberated, but those who failed to establish any relation were not liberated. If someone expresses that God is mine, it extremely pleases the Lord. In reality, except for God, there is no one whom we can call ours. Due to your materialistic tendencies, you might become ignorant of God, but God never forget you. One more question was expressed by a person in front of Swamiji. After acceptance of God's relation, can God be realized even on persistence of worldly desires? Swamiji says yes. God can be realized even on persistence of worldly desires, and the desires will not persist once God is realized. The principal mistake has been the erroneous embracing of what is not ours, like body, senses, mind, intellect, and now who belong to us. We did not embrace that God. This single blunder encompasses every other mistake. In mathematics, on omission of even a single step or a digit, everything becomes incorrect. and no mark is awarded. That's why you must at least accept I belong to God and God is mine. To eternally reveal the Lord and to acquire His perpetual love. It is a must to embrace the fact that God is mine. Like a child declares that the mother is mine, similarly, God is mine. The sentiment of belongingness towards God is the mantra for eternal love. It reveals the presence of God. You must invoke this feeling from within that why is my mother not taking me in her lap? You must firmly believe God belongs to you. This will have an immense outcome and your existence will prove victorious. My heart will be extremely delighted if you do so and you also be happy. You will be blissful. This acceptance is pure, profit with no loss of any kind. This wisdom is not ordinary, it is a conclusive essence of the Vedas, Gita, and Ramayana. Even if you do not believe the truth will remain absolute, it can never be a lie. You just have to embrace it from your end. Then, even if a void persists, it will be up to God to seal it. But you must never disregard this once accepted. Keep on reiterating, I belong to God. This will naturally make you pristine and pure. Is God feebler than a philosopher's stone, which transforms metal into pure gold? The purity which is attained by acknowledging the relationship with God can never be attained by our endeavor. The benefit which is not obtained even after years and years of satsang will be achieved in a single day by accepting our belongingness to God. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teachers, trainers, professor, professional, officer, official, listener, learners. I thank all of you. Nice to see you.